Hi, I'm Shawn Garner. I'm an attorney with Deason Garner Hansen, and today we're going to talk about common planning approaches that most people consider. First of all is what we call the DIY type planning, and that is where individuals will attempt to do it themselves without any assistance from an attorney or even going online and getting online forms. They'll name individuals, maybe their partner or their spouse, on a joint account. They'll name them on the house. They'll name them on the title to the car. That way, if they pass away, then their spouse will own everything by right of survivorship. They can also name beneficiary designations on a bank account. That's called a POD, or payable on death designation. And they can also name beneficiaries on life insurance and 401ks or other retirement accounts. We're going to compare that to your traditional estate plan, which is a will combined with a power of attorney, and then compare both of those to a comprehensive estate plan using a living trust. That way you can see how each of those types of plans might work in your scenario and the pitfalls that each of them may have. So let's get right into it. First of all, I want to talk about the consequences of failing to plan at all. If you don't do any planning, then the court will likely have to intervene at some point if you become incapacitated, because somebody's going to need to make legal decisions on your behalf. They're also going to need to make healthcare decisions on your behalf. Without preparing an advance directive, a healthcare power of attorney, and a legal durable power of attorney, nobody has that authority without the court appointing them, and that is going to go through a guardianship or a conservatorship to get that. So we want to avoid that. It's surprising to learn how many people don't have any estate plan in place when they pass away. They don't have any documentation in place if they become incapacitated. The recent experience with COVID-19 really brought this to the forefront, where people were going into the hospital and there was nobody designated to make medical decisions for them. 55% of Americans pass away without any estate plan in place. So let's not have that be you. That's why you're here watching this video and seeing what your options are. We're going to play a little game, first of all, to start this off. And it's going to help us understand why people don't get planning in place. So we'll go to this Family Feud type scenario here and think of the top 3 reasons why. If you thought about it for a moment, let's take a look at what the answers are. Number 1, costs. Most people are very concerned about how much it's going to cost to get their estate plan in order. Number 2, where to start. Many people have access, almost everybody has access to the internet, either through their cell phone or tablet or just their computer at home. And so there's a wealth of information that was beyond what kings and scholars had just 100 years ago, or even 50 years ago. But the real dilemma is determining what information is actually useful for you and what is correct and what might not lead you down the right path. Finally, the number 1 reason people don't do estate planning is good old-fashioned procrastination. They think that they'll have more time tomorrow to do it. They don't want to think of these issues of death and disability, so they keep pushing it off down the road. And this video is to help you understand what your options are, to understand what the costs are. Unfortunately, it can't help you with procrastination. You have to make that decision up in your own mind to not procrastinate anymore, to get something done. So we'll give you an option at the end of the video to get started, or what direction to look to get your estate plan in order. Now, the easiest way to present these concepts is to go through hypotheticals. So we're going to present this family to you, and this is the Jones family. This is Bill and Mary Jones. Bill and Mary, this is their second marriage. Bill has a son from a prior relationship. Mary has a daughter from a prior relationship. So they've been married for several years, and they consider their 3 different options for doing their estate planning. First, they do nothing, and they have an estate worth of $500,000. That includes their cars, their houses, bank accounts, and retirement accounts. They go out on a date with no planning in place, and there's a car accident. So let's see how that works out for them. Bill's killed, unfortunately. Mary is seriously injured, so she goes to the hospital. And with the current state laws in Arizona specifically, half of Bill's assets will go to Mary because he has children that are not also her children. If they only had their joint children, then all of his assets under the state default law would go to Mary. This is called intestate succession, and that's not a word that you have to remember for anything, but that is the word used for individuals that have no planning in place. That's how their property passes. The state law governs. Most people aren't comfortable with that, so Mary is only going to get half of what Bill had, and that might make it so they have to sell the house because Bill's kid, John, is going to get the other half. Now, John, he's one of those kids that he's nice enough, but he's one of those failures to launch. He is always getting mixed up with the wrong crowd. He's got some drug addictions. He sleeps until noon. He's always bumming mom and dad, or bumming money off of mom and dad for the next get-rich-quick scheme, and he never really has held a steady job himself. Either way, he's getting half of all of the property that Bill had, at least his separate property. And that is a big problem here because that's going to leave probably Mary in a very difficult situation and put John in a situation where he's got a whole lot of assets now and could probably exacerbate the problem that he has with drug addiction and choosing bad friends. So obviously that wasn't a very good option. So let's try a different option, which is the DIY. They do something proactive to get their plan in order, but they're going to do it without any attorney or any professional documents involved. They're just going to name each other as joint on their accounts and beneficiaries for each of their assets. So let's give them a do-over. We're going to push this great big green do-over button and start again. So they go out on date night after naming each other as beneficiaries on each other's accounts or naming and adding each other to the deed to the house and the titles to the car. And then they go out on date night again. Same scenario here. Bill's killed and Mary's incapacitated. But instead, Mary is going to get 100% of the assets because she was joint on the deed to the house. She was joint on the titles to the cars. She was joint on the bank account. She was named as the beneficiary of the life insurance. Bill updated his IRA to name her as a beneficiary. So everything is hers. This seems to have solved all the problems, and it was cheap. So why not go this way? There is that one issue of incapacity because Mary, remember, she's seriously injured in this car accident. And whether it's a car accident or dementia, Alzheimer's, just declining health in general, most 70% of Americans will go through a steady decline for about 2 years before they pass away. 1 to 2 years of which they won't be able to manage their own affairs. So we're going to need a plan for incapacity. In this case, that DIY planning that they did for themselves did nothing for incapacity. They didn't create a power of attorney. So the question is, who's going to manage Mary's affairs? They're going to have to go through the court, and somebody, most likely her daughter Susan, is going to apply for a guardianship and a conservatorship so she can make healthcare decisions for Mary and financial decisions and manage her legal affairs. That's not optimal. There's a loss of control. It's time consuming and it's expensive. So we're going to give them a do-over. I like to call this the Groundhog's Day. So if anybody's watched Bill Murray's Groundhog's Day, great movie. We're going to hit that 6 a.m. again. We get to start over. Bill and Mary are now alive again. And we're going to talk about traditional estate planning. So with traditional estate planning, we're going to use a will, a last will and testament, a property power of attorney, which most people recognize as just a power of attorney or a general power of attorney, and a healthcare power of attorney. Now, a traditional estate plan is the minimum that anybody should be considering if they're an adult, because even if you don't have very much money or you don't have a complex estate, no big white house at the end of a long driveway lined with oak trees, there are important decisions that need to be made. For example, if you're a parent of minor children, what more important decision is there than who will be the guardian of your children if you die or become incapacitated? A will can name that guardian. A power of attorney can also help name that guardian. Who's going to be making legal decisions for you and healthcare decisions for you? Your healthcare power of attorney and general power of attorney will help designate those individuals. So Bill and Mary, understanding this, they do a little search, ask Siri on their iPhone or do a Google search to find an estate planner to do that. And what they find is just the general jack of all trades planner that he does DI or DUI defense, criminal defense, and divorces, and he also does a will here and there. So they go with this guy, or they could go online and fill out their own plan online. Now, there's some amazing tools online, especially with AI being available. And I like to use AI quite a bit when I'm helping my clients do their estate plan. However, the key is understanding what all the nuances are and what questions to ask. Many times when I sit with my clients, the questions that I ask them cause them to pause for a moment and say, we didn't consider that. It's impossible to get a good response out of AI if you don't give them the proper prompt. So either way, we're going to take a look at how this works out with this budget attorney or even going online. They get their will, power of attorney, and healthcare power of attorney put in place. They go out on the date. They have the car accident. Bill's killed. Mary's injured. And now Mary's going to have that consideration of what to do because she's incapacitated. Well, we get to skip the court process because Susan is named as the power of attorney. She's named her for financial decisions. She's named her for legal decisions. She's named her for healthcare decisions. Of course, she might have named Bill first, but seeing that Bill's passed away, Susan is now in place to make those decisions so we can avoid that court process. What about when Mary passes away? What's going to happen? Well, she has a will, and a lot of people think if there's a will, then the asset should automatically transfer to the beneficiaries designated. Well, in our firm, we have a saying, where there's a will, there's a probate. And the reason why is because you can't take a will to a bank or to a title company, to the DMV, and expect them to accept it and transfer title into the name of the beneficiary. They are going to ask you to take the will to the court and have it accepted into probate and have a court order appointing a personal representative that then, under the authority of the court, has the ability to transfer the assets to the beneficiaries appropriately after all the assets or all the liabilities of the estate have been paid off. So let's say that they go to court and Susan is appointed as a personal representative. A big benefit of having a will is it'll typically waive the bond that is required by statute for a personal representative to take control over a deceased person's estate. So that's nice. She doesn't have to post bond. That's an insurance policy with the court to make sure she doesn't run off with all the assets of the estate. She is designated as the personal representative, so it gives the court clear instruction as to who is the person to be in charge, and the court generally will follow that instruction unless there's a significant problem with that personal representative. Maybe they've got addiction issues or are incarcerated or incapacitated themselves. Finally, there's clear instructions as to who is to inherit the property. Now remember, this is Mary that passed away, but the assets were Bill's and Mary's, so her will is likely going to include John as a beneficiary. Bill and Mary created the wills at the same time. They probably said in Bill's will, if I die, everything goes to Mary, and if she dies, and I divide it equally between my son and my stepdaughter Susan, and Mary's will say the reciprocal. If I die, it all goes to Bill. Otherwise, it goes to my daughter Susan and my stepson John. So let's say that happens. In John's case, what is he going to do with his inheritance? The average time in America for a beneficiary to spend all their inheritance is 1 year. And that's distressing for a lot of parents when they consider all of the time that they put together to build up their estate, their legacy, that it's all gone, it's blown within a year. And not only that, that the child is worse off for it. John, he's probably going to get some new friends, this big jacked up truck, probably going to indulge in some drugs and some parties. And before you know it, it's all gone. With Susan, she's more responsible, but I want to introduce you to Jason. If Susan is married to Jason, and she's a pretty straight arrow, she's a good kid, but Jason, he's their weak spot. And if she deposits her inheritance into a joint account with Jason on it, she's gifted him essentially half of her inheritance. If she were to keep it separate, then it would become a separate asset and it wouldn't be subject to the divorce proceedings. But in this case, let's say Jason files a divorce 6 months later and she's deposited all her inheritance in there. That's going to be commingled into community property, and Jason's attorney is going to make a big argument that he's entitled to a lot of that inheritance. Some disadvantages of probate, we can sum them up with there's a lot of time and money involved. There's no protection against John's immaturity as far as financial decisions or a divorce that's pending for Susan out there. There could also be multiple probates. The court only has authority to transfer assets or give authority to the personal representative to transfer assets within the state. So if there are assets, for example, a condo out of state, the court doesn't have any authority over that asset. There's going to have to be another probate opened up in that state to transfer that condo. So that's a major disadvantage. So what we're going to do is give them another Groundhog Day. 6 a.m. goes around. Bill Murray wakes up, gets a fresh try to see if we can make this better. So this time, we're going to go with a comprehensive estate plan. Now, a comprehensive plan includes not only a living trust, but also a will and a power of attorney, including a healthcare power of attorney. A trust is not in place of those documents. It is a supporting document with those documents. So let's walk through how that might work and what a trust is. A living trust is like a big treasure chest that can hold title to any asset. It can hold title to cars and houses and bank accounts. It may not be a good idea to put all assets in a trust, but a majority of the assets you can put into a trust and then have one designated document that says who is in control of those assets, especially while you're alive, you will be, and who is the beneficiary of those assets? Again, you would be. There are 3 components for creating a trust. Number 1, the trustors. An easy way to remember that is the trustors are the creators of the trust, so trustor, creator. The second is the trustee. That's just a fancy word for the manager. Trustees manage the trust. The third is the beneficiaries. The beneficiaries get the benefit of all the assets in the trust. So when you create a living trust, you are the trustor, you are the trustee, and you are the beneficiary. So Bill and Mary create this trust, and they are all 3 of those roles. Now, it's important for them to put their property into the trust. It's very frequent, too frequent, in fact, even when attorneys are involved, that the trust is created, but the assets are not properly transferred into the trust. We call this funding, and it's critical that the assets are in the trust. Because what happens is if they're in the trust is what I like to think of as an immortal entity that will continue on past your death. Hence the name living trust. It's living when you create it, and it continues living when you pass away. You can put the assets in that, and your instructions will carry on and apply to those assets after you pass away. The manager over those assets will be whoever you designate. The beneficiary of those assets will be the people that you name, instead of the court getting involved and directing who is going to be over the estate and who gets it. So with a living trust, it's an important tool to couple again with a will, but in this case, we're going to do a pour-over will. The will is just going to be a supplement to the trust, kind of like a bucket that is there to catch anything that falls through the cracks. If there's any assets that remain in your name individually, your will name the trust as the beneficiary of those assets. Or if you're entitled to payments after you pass away, your will redirect those payments to the trust. The power of attorney is important because legal decisions for you personally have to be made through that power of attorney document. A trust only manages assets. It doesn't manage legal decisions for you as a person. And healthcare decisions, same thing. You'll need a healthcare power of attorney. So the common questions we get asked when we talk about trusts are fees. What are the fees to buy new property to put in the trust or sell property out of the trust? What are the fees for new complex tax forms, and are there annual or quarterly management fees? And the answer to each of those questions are no, no, and no. There should be no fees on any of those if you have a good relationship with a good attorney that is actually capable of doing this and teaching you how to follow through with it. So for example, if I create your trust and I put your house in the name of your trust by redeeding it out of your name into your trust, if you want to sell that house, you go to the title company. When there's a close of escrow, they're going to have you sign the deed, and after your name is going to be comma trustee. So in this case, it'd be Bill and Mary Jones, comma trustee. They sign the deed that way, and that can convey the deed out of their trust. Very easy. It's not going to take any additional fees, attorney's fees, or closing fees to do that out of a trust. So it's easy to convey a house out of the trust. When they buy a new home, they'll instruct the escrow officer, hey, we have a trust. And hopefully they present the certificate of trust that has the name of the trust on it. The certificate of trust is a ticket that you're going to present to the banks, to each institution that is going to be dealing with the trust. You'd be giving it to the escrow officer in this case, and they would make sure that the deed names the trust as the owner of the property and not Bill and Mary individually. So it would cost nothing more to sell the property out of the trust or to incorporate new property into the trust. As far as income taxes, the trust uses your Social Security number as a tax ID. So it's your general 1040 easy to file your tax return. There is no additional tax forms or complex documents that you're going to have to file. And as far as management, I don't know about other attorneys, but for our firm, we help all of our clients by giving them free consultations on any questions that they have about their estate plan. So if they have questions about buying or selling assets or understanding their trust, we give those answers and consultations free because we're so confident that when you understand this trust, you're going to be able to do it regularly on your own. And we want to maintain a good relationship even after for your family, so they can ask us those questions and we can ensure they understand how useful the trust is and make sure that they can administer the estate without any complexity or undue burden there. Now, another question that comes up a lot is about Medicaid. People get informed about Medicaid a lot over the internet, and they hear about Medicaid trusts. They hear about how you can put your assets into one of these Medicaid trusts and get approved for Medicaid if you need to without losing your home and all of your life savings. Most of that is what I call a snake oil solution, and you just have to follow the common sense rule that you learned as a kid that if it sounds too good to be true, it usually is. Medicaid trusts, we don't typically recommend them in this firm. It is very difficult to anticipate all of the different scenarios that are going to be involved in your personal plan to make a Medicaid trust actually work for your benefit. But there are advantages to having a trust when it comes to Medicaid. So I just want to point out, first of all, what's on the slide here, and that is that you're not going to get good Medicaid advice from going to the Medicaid office. In fact, in Arizona, specifically in their instruction manual for the advisors, they're called eligibility specialists. It says, do not give advice recommending actions that can be taken to make the customer financially eligible. So even if they understand that there could be some options available to you They can't give you that advice. I can, and I will. And in a trust, I'm able to not only give you or your agent under your power of attorney that advice, but help walk them through those steps. Now, a lot of people think, well, I have too much money to even qualify for Medicaid, so what does it matter? Let's go through and do what we call the all text quiz. And it's all text because in Arizona, Medicaid is administered through Arizona long-term care system, all text. And so we've got this couple and they've got assets that are fairly significant. Let's say they've got $700,000 in total assets, and that includes their home, which is $500,000. Their home furnishings, they've got some nice paintings, some nice antique furniture, $100,000, a Mercedes-Benz at $70,000, a savings account of $20,000, and then they prepaid their funeral plan with $10,000. Their monthly income is very generous. It's $10,000. Husband makes a great pension, so $8,000 a month. The wife makes Social Security of $2,000. The question would be, if the wife were to have a stroke and to become incapacitated, would she qualify for long-term care? And the answer here is yes, she actually qualifies. Many of you may be surprised by that answer. And the reason we put up this scenario is to show that Medicaid is actually a pretty broad system. A lot of people qualify for it. There are limitations, and the biggest problem is the application process and understanding what assets are non-countable for determining the eligibility and what assets are countable. So let's go through another quiz here, another scenario to see how well we understand this concept. Let's do another quiz. Let's take another couple that has a more modest estate. They have $100,000. They've got a park model that they rent. They don't own the lot. They just rent the lot. They actually own the park model. It's $35,000. They have home furnishings that doesn't have any real fair market value because they're not antiques. They're nothing special. Most used furniture doesn't go for anything. They've got a Crown Victoria worth $4,000, $5,000 in the savings account, and the husband let's say that he's got a retirement account of $55,000. They both make $2,800 a month in income, so for a total income of $5,600. So this is about half of what the other couple made, and significantly less assets. But if they were to apply, if she were to have a stroke, the wife were to have a stroke and need long-term care, if they were to apply for Medicaid, most people would think these are the people that Medicaid is set out to provide a safety net for. The crazy thing is they would get denied. So many people ask why. Well, there are two categories when All-Tax or Medicaid looks at in determining eligibility. One is countable assets. The maximum amount of assets you can have to be qualified for Medicaid is $2,000. And the maximum amount of income that you can have is approximately, and it goes up with inflation, but approximately $2,700. So if you're a dollar over the income or the assets, then it's going to result in a disqualification for benefits. Now, as far as the assets go, they only count the applicant's income. So that's why the first couple, we'll go back to that slide, she had only $2,000 worth of income. It didn't matter that the husband has $8,000 of income because it only applies her income. As far as the other assets, all of those assets that we named are non-countable assets. So essentially we can pigeonhole certain assets into a non-countable category, and they won't count towards that $2,000 maximum threshold. With this other case, we'll go back to it. Their retirement account, unfortunately, in Arizona is a countable asset, and it puts them over that $2,000 mark. So that's one reason of 1,000 that you could get denied for Medicaid. Also, she makes too much income. She makes $2,800, where the maximum is $2,700. So there are ways to help her qualify and go through strategies using a trust. She's not going to automatically qualify, but if she had a living trust in place, then her husband could come into us and we could help him understand what strategies are available to make the current assets that he has non-countable. And we would walk through those strategies. He would have authority because of the trust and the power of attorney that was put in place to administer the plan that we put in place. And then she could qualify for long-term care. So what I'm not saying is that a trust is a cure-all that will make everybody eligible for Medicaid. What I am saying is that a trust can allow somebody that you have confidence in to meet with me or another attorney that has a good understanding of the Medicaid laws, and then put together a strategy that will help you navigate that application process to qualify, or at least put you in the best scenario possible to qualify for the benefits that you deserve. So what we're going to do is we're going to give the Jones family a do-over. They, instead of going online and doing their own trust and estate plan, or going to some jack-of-all-trades attorney and getting it done, they go to an attorney who does this every day for a living. I've done personally over 10,000 trusts. I've seen a lot of them, what the nuances are, what works, what doesn't. They call it the practice of law because I'm constantly trying to improve, but I see the scenarios that work and which ones don't. We will put together a comprehensive plan for our clients that includes not only a trust, but a will, a power of attorney, and an advance directive that says what the client wants to have happen. If they are incapacitated, they have their quality of life is flatlined essentially, and they're a vegetable if they want to be kept alive on life support or die of natural causes. So we put this plan together for Bill and Mary, and then they go out on the date, and the truck runs the red light. Bill's killed, Mary's incapacitated. So what happens then? Who is going to take over the estate? Well, all their assets are in the trust, and Mary is the beneficiary of that trust. So she is going to benefit. She's a designated individual to continue to receive the benefits of those assets. Susan is going to be the one in charge of making sure she gets those benefits. Now, Susan as a trustee, kind of think of her like the teller at the bank. When you deliver your paycheck to the teller at the bank, he doesn't own that money. He's just keeping it safe until you designate where it goes. That's Susan. She keeps it safe and looks at the trust to designate where it goes. It's going to be used for Mary's health and support, and she can also be named as the power of attorney to make legal decisions for Mary, as well as a healthcare agent to make healthcare decisions for her. But what about when Mary passes away? Is she going to have to go through probate? The answer is no. A living trust avoids probate because none of the assets are in Mary's name. The probate process is for the court to take authority over assets that are in the name of a deceased individual. None of the assets are in Bill or Mary's name. They're in the trust, and the trust is living. So the court doesn't have any authority over these assets, and the trustee is the one that gets to administer them. We get to avoid any needless expenses, time delays. And what's really neat about a trust is it can hold assets from all 50 states. It shouldn't hold assets from outside the United States, but it can hold assets from all 50 states, and it can apply and be administered in all 50 states. So that condo in California or whatever state that is not a problem anymore. As long as it's titled in the trust, Susan as a trustee can follow through with her parents' directions to either sell it or distribute it to their designated beneficiaries. So let's get now to the administration that Susan's going to be doing. Susan is a trustee. All the assets are in the trust. And let's say that the trust names her and John equally as beneficiaries. How is that going to be distributed? Well, Susan could, and oftentimes is the case where the client wants everything to be liquidated and then just a check sent to the beneficiary, or she could actually keep the assets. Even if they are liquidated, the house is sold, the account's in the trust, and then separate the trust into two separate trusts. Let me show you a visual of what that might look like. So we've got the Jones Family Trust. That's where Susan can exercise all of her authority to sell all the assets. There's an account that's set up in the trust to receive all the proceeds from the sale. And then she can set up a subtrust for John according to the terms of the trust. It's got to be in the terms of the trust, but we typically write those in there. Now, John has his own inheritance trust. We call it typically a trust fund or a subtrust. And then Susan will also have her own subtrust. Why would we want these subtrusts? Well, remember, John, he's not really competent to manage a whole bunch of assets, especially if he were to get a windfall of $250,000 right off the bat. He's going to spend it on drugs or lose them in lawsuits and parties. So Susan could be named as a trustee of John's share, or you could have a trusted friend, a professional trustee like an attorney or an accountant do that role if you don't want to create any animosity between Susan and John. The point is, the trust can have provisions in there that will provide for reasonable expenditures out of the trust for John's benefit without exposing them to any of his liabilities. The trust is protected from his liabilities because the assets in the trust are still Bill and Mary's assets. John didn't put anything in the trust, so none of his liabilities actually get to attach to the trust. As far as Susan goes, remember, the big issue there was with Jason. And in this case, if you inherit property, that inheritance is separate property. You keep it in a trust, and that puts a nice glass jar around that inheritance. It keeps it airtight from being commingled with community property. Separate property is going to be hers and stay hers if she were to get a divorce. It can also protect her against lawsuits or other issues that she may run into as life goes on. So it can allow her to keep her inheritance protected. In Arizona in particular, she can even be named as her own trustee. That means she can manage her subtrust and be the beneficiary of it as well without losing any protections under the trust, so long as it's drafted properly. Now, there are a lot of ways that you can look to save a buck, but there are certain things that you shouldn't be pinching pennies. You've heard the saying, a penny wise and a dime foolish. So what are some of those things? Well, parachutes, right? You don't want to figure out at 20,000 feet that your parachute wasn't made by the highest quality and that ripcord isn't going to actually deploy the chute. Surgeons. You're probably not looking for surgeons on Craigslist, right? Or trying to find the cheapest surgeon to do the procedure. You want the most qualified one that's done it 1,000 times and knows every complication that can arise and how to address that, so you come out of it with the best case scenario. The same thing applies with attorneys, specifically estate planning attorneys. And what they all three have in common is you don't know what you've got until it has to work, until it's too late. So once you become incapacitated or pass away, the estate plan has to work. It either works or it doesn't. So we recommend putting value into those types of things, and we want to be very clear as to what we charge for our estate plans. So we're going to talk about that right now. For a single individual, we charge $3,095 for your typical estate plan. Now that includes not only a living trust, but a will, a power of attorney, a healthcare power of attorney, the HIPAA documents that go along with that, the advance directive, the cremation directive, every document that is necessary for you to have a comprehensive estate plan, that's included in our comprehensive package. It also includes consultations with us indefinitely, so you can keep understanding what your estate plan does and how to manage it as time goes by. If you're a married couple, the full fee is $4,095. Now, here's a dirty little secret, that if you don't have a trust properly funded, it's the same as a will. Again, funding is a transferring of the assets out of your name individually into the name of this trust, this entity that's immortal, that's going to live beyond you, so the court doesn't have control over the asset that's held in your name. We need to do that with the house, the bank accounts, all of the assets, and have a proper designation through the trust with IRA accounts, 401ks, or any other retirement accounts. We call those qualified or deferred accounts, we don't want to put those in the trust immediately, but we want them to run a similar path as a trust. So they're going to make up part of a comprehensive plan. Putting them in the trust initially it will result in immediate taxation of all of those deferred taxable accounts. So you don't want to do that. It's important that you have somebody guiding you that has that financial expertise to give you the proper instructions and walk you through those steps. Our firm spends a lot of time on the funding of the trusts. We have 5 full-time licensed realtors in the office. We also have licensed financial advisors in the office. We understand how to work with vehicles to make sure it's going to be easy as possible if you're going to buy and sell vehicles frequently, to do that throughout the trust. And we can also help you update beneficiaries if necessary. So those are things that we offer in a comprehensive estate plan. We want to make it work as well easy for you, because you could have the best plan out there drafted in this nice leather binder, but if it's not accessible, then what good is it? So we put it on a USB card, and we also save it in our system, our secured system here. So when your family needs access to it, they can call us and we can help walk them through the steps of administering your trust. If you have this card in your wallet, then let's say your spouse goes into the hospital for an emergency surgery. You can have access by this USB to the healthcare power of attorney if we're not open during business hours. Otherwise, call us during business hours and we can email or fax that healthcare power of attorney over to the healthcare professional, or use the power of attorney for legal decisions that need to be made. So again, we want to talk about not procrastinating. In order to get the plan done, make up your mind to do something. We'd love it if you'd call our firm and set up a consultation so we can actually walk you through the options for getting your estate plan set up. We offer a free consultation where we'll map out what a comprehensive estate plan would look like for you. We'll print that out, we'll send that home with you, and what we'd like to do is have you consider us to do your estate plan. If we're not the right fit, then let's just figure that out right off the bat. There'll be no fee, and we won't have any further obligation to you, and you won't have any to us. If you do like what we have to recommend, then let's go ahead and move forward. We'll set a date to have your planning actually signed and put in place. So we're not procrastinating anymore, and we're going to move forward with this planning. That is estate planning basics, and we hope to hear from you soon.